Picture this. It's the dead of night in Sydney's West, Clyde specifically, back in October 2012. The city's mostly asleep, right?
Mm-hmm.
But here, on this quiet suburban street, a plan, well, a plan born out of desperation, maybe fueled by drugs, is about to kick off.
Yeah, not exactly Ocean's 11.
No, definitely not. This was like a grab for quick cash from a local brothel, allegedly planned by one guy, Jefferey Sio, and then carried out by his childhood friend, Richard Filihia.
But like so many of these things, it just goes completely sideways.
Horribly wrong. It twists from this, planned robbery into a fatal encounter. And at the center of it all, tragically, is Brian Gaudry.
The night receptionist.
Yeah, the night receptionist at the brothel, whose life was just violently ended during this botched heist.
And that scene, it really sets the stage for something much more complex than just the crime itself. It's a story tangled up in personal histories, betrayal, definitely substance abuse.
Yeah, the drugs seem central.
They do. And also, the really unexpected ways a single brutal act can echo through the entire justice system. It forced, a serious look at some fundamental legal rules.
We're not just talking about a murder trial here.
No. We're diving into a case that actually significantly changed the legal landscape in Australia, especially around how courts deal with evidence from accomplices, people involved in the crime themselves.
Right, and that's exactly what we want to unpack in this deep dive. We've got the source materials, court judgments, the whole lot. We're going to trace the story of the Clyde Brothel murder from the very beginning.
From the planning stages.
Yeah, the planning, the violence of that night, and then its really complex path through the courts, all the way up to the High Court of Australia.
And the goal isn't just the who did what, is it?
No, it's about understanding how the legal system grappled with the evidence, especially Filihhia's statements, and how this one case, Sio v. the Queen, became such a landmark decision, reshaping those crucial rules of evidence. So let's get into this tangled web.
Okay, let's start right at the beginning. Because the sources show this wasn't, like, a spur-of-the-moment thing.
No, it seems like it had been brewing for a while.
Yeah, quite a while.
Okay.
We hear from Miss Gaudry, she actually worked at the brothel in Clyde. And she testified that Daniel Sio had talked to her about robbing the place way back in late 2011 or early 2012.
Wow, that's months, maybe even a year before.
Exactly. And it wasn't just idle chat either. Mrs. Gaudry said Sio got quite specific. He actually drew a diagram.
A diagram, like a floor plan.
Yeah, a plan of the brothel's layout, right there on her writing pad.
Okay, that's pretty concrete planning, more than just talk.
Definitely. And according to her, next to this drawing, Sio wrote a note, a really chilling instruction for her.
What did it say?
It said, keep tabs on money that Brian's holding.
Brian Gaudry, the victim.
The victim, yeah. The night receptionist. So this note, the drawing, it strongly suggests premeditation, doesn't it?
Absolutely. Identifying a specific person, the likely cash holder, planning the logistics, it paints Sio as, well, the alleged architect here.
It certainly points that way. It shows a developing scheme, a target, a focus on the money, months before the actual event.
So the target and the basic plan are potentially in place early on. Now, any robbery needs tools, right? And the weapon here was pretty specific.
Yeah, the sources describe it as a hunting knife, a kind of Crocodile Dundee-style knife, apparently.
Right. And it belonged to a Mr. Robert O'Hare.
That's right. Robert O'Hare, he was a friend of Miss Sarah Coffison, and Coffison was also friends with Daniel Sio, so there's a connection there.
Okay, another link in the chain. And O'Hare was staying with Coffison.
Yes, around the time this all happened, he actually kept this knife out on a television cabinet in her living room.
Why there? Seems an odd place.
Well, the sources say he felt uneasy about some of the people visiting Coffison's house, reading between the lines given the context.
Drugs, maybe? Associated people?
It seems likely, yeah. He wanted the knife handy, perhaps for self-defense. It paints a picture of the kind of environment they were in.
Definitely. And O'Hare didn't just own the knife, did he? His evidence was pretty crucial.
Absolutely crucial. He testified that around early October 2012, so closer to the actual robbery now, he overheard Sio and Coffison talking.
Talking about what?
Talking about plans to rob a brothel.
Wow. So he heard them discussing it.
He did. And then, just days before the robbery, around October 21st, he noticed something.
The knife.
His hunting knife was gone, missing from the TV cabinet.
And did he ask them about it?
He confronted both Coffison and Sio, and their answers, according to O'Hare, were, well, dodgy.
How so?
Inconsistent. Seemed designed to put him off. Coffson claimed he must have packed it in his backpack when he left earlier. Sio apparently backed her up on this story.
And O'Hare knew that wasn't true.
He knew they were lying, and this evidence is vital, isn't it? It directly connects Sio and Coffson to getting hold of that specific weapon right before the crime. It really bolsters the Crown's case that Sio provided the knife.
Okay, so we have the alleged planner, Sio, the target, Gaudry, the weapon, O'Hare's knife, and the person who overheard discussions and noticed it missing, O'Hare. Now, who else was involved on the night? Miss Sarah Coffson was in the car, right?
Yes, Sarah Coffson, also known as Sam. She was in the front passenger seat when Sio drove Filihia to Clyde. And her role wasn't just passive. The sources show she acted as a go-between just before.
House.
The day before the robbery, October 23rd, Richard Filihia specifically asked Coffson to pass a message to Sio.
What message?
Just letting Sio know where he was staying, the Cars Park Motel.
Seems simple, but it shows coordination, right?
Exactly. It shows Coffson facilitating communication, Sio and Filihia linking up just before they execute the plan the next day.
Okay, let's move to the morning itself. October 24th, 2012, the day it all went tragically wrong. Sio allegedly picks up Coffson and Filihia. What happens then?
Well, the sources describe a stop first. Sio reportedly drops Coffson and Filihia off at a park, just for about 5 minutes.
Why? Any idea?
Then he comes back to the car and gives Filihia some clothes.
Okay. Maybe changing clothes, a disguise, something easily disposable.
That's often the thinking, isn't it? A practical step before a robbery, to avoid being identified or leaving traceable evidence.
Makes sense. So after the park stop, they head towards Clyde.
Yes. And there's a crucial detail noted about Filihia during this drive.
What's that?
He was affected by ice, crystal meth.
Right. That adds a whole layer of volatility and maybe desperation to the situation.
Absolutely. It speaks to that chaotic element, often tied to crimes driven by addiction and the need for drug money.
And that state of mind. It's critical context to what happens when they arrive. Sio doesn't just pull up outside the brothel, does he?
No, his actions seem quite deliberate. He bypasses the front, reverses into a factory driveway some distance away, stops the car, kills the engine.
Like a staging point.
Exactly. This is allegedly the final prep moment. According to the Crown's case, this is where Sio gives Filihia the hand-drawn layout of the brothel.
The one Miss Gaudry saw him draw.
Potentially, yes. And the hunting knife, O'Hare's missing knife. And specific instructions on how to carry out the robbery inside.
This is the absolute core of the case against Sio, isn't it? That he wasn't just the driver, but the one providing the means and the method.
Precisely. The architect, not just the getaway driver. So Filihia, armed with the knife, allegedly high on ice, gets out of the car and walks towards the brothel.
And he gets buzzed in by Brian Gaudry.
Yes. He pushes the buzzer, Mr. Gaudry lets him in, and that's when it all unravels inside.
Rapidly and tragically.
Yeah. Once inside, Filihia confronts Mr. Gaudry. There's an altercation. The sources and later court admissions are clear on this. Filihia pulls out the knife, he pursues Mr. Gaudry,
And then
he stabs him, inflicts a fatal wound. After the stabbing, Filihia takes money described as being in a pencil case from Mr. Gaudry's back pocket.
And these facts about Filihya's actions, they weren't really disputed later in court.
No. Formal admissions were actually made on Sio's behalf at his trial. They admitted Filihia committed armed robbery, was armed with a knife, stabbed and wounded Mr. Gaudry, and that Mr. Gaudry died as a direct result.
But Sio's defense was completely different.
Completely different. They stuck to Sio's initial lie to the police that he'd just driven Filihia there for sex, implying he knew nothing about any robbery plan, knew nothing about the knife. Total denial of involvement in the crime itself.
Such a devastating outcome for Brian Gaudry. Okay, before we track this through the courts, let's just quickly recap the key players we've identified from the sources, the dramatis personae, if you will.
Right, good idea. So first, Brian Gaudry, the victim, the night receptionist, tragically killed.
And Daniel Jeffery Sio, the alleged mastermind, according to the Crown, planner, driver, alleged provider of the map, the note, the knife, the instructions, lied to police initially.
Then Richard Filihia, Sio's childhood friend, the accomplice who went inside, confronted Gaudry, inflicted the fatal stab wound, notably affected by ice.
Miss Sarah Coffson. In the car. Friend of Sio and O'Hare. The knife was kept at her house. Robbery plans allegedly discussed there. Acted as a go-between.
Mr. Robert O'Hare, owner of that distinctive hunting knife, heard Sio and Coffson discussing a brothel robbery. Noticed his knife was missing right before the crime, confronted them about it.
And finally, Mrs. Gaudry, the brothel employee, spoke to Sio about robbery plans much earlier. Saw him draw the layout and write that note about Brian Gaudry's money.
A relatively small group, but deeply interconnected. Their lives collided violently that morning.
Okay, so the crime happens. What's the immediate aftermath? How does the investigation unfold?
Well, Filihia's actions immediately after are quite surprising, really.
He didn't just disappear.
No. Later that same day, October 24th, he actually reports to Hurstville Police Station.
To confess.
No, not at all. He was there because he had unrelated bail conditions requiring him to report in regularly. Pure coincidence, it seems.
But the police already had eyes on the brothel's footage.
They did. By the time Filihia walked into the station, police had obtained the CCTV footage from the Clyde Brothel.
And could they identify him?
Yes. Apparently, he'd shaved his head after the robbery, maybe trying to change his look. But despite that, police recognized him from the footage.
So they arrested him right there.
Arrested him right there at the police station.
Okay, Filihia is in custody. What about Sio? And how did Filihia's arrest impact Sio's case?
This is where things take a really crucial turn, legally speaking. Filihia eventually pleads guilty to murder and armed robbery, but in separate proceedings.
Meaning he wouldn't testify at Sio's trial.
Exactly. He was considered unavailable as a witness for the Crown at Sio's trial. This had huge implications.
Because the Crown's case against Sio, claiming he was the mastermind who gave Filihia the knife and instructions,
Now had to rely heavily on what Filihia had already told the police after his arrest, his out-of-court statements.
Right, the police interviews, the sources mentioned several of those.
Yes. Multiple electronically recorded interviews, ERISPs, and statements were taken from Filihia on October 24th and 25th, right after his arrest. And these recordings and statements became the focus of intense legal argument later on.
Because they contained the key claims against Sio.
Precisely. During these interviews, Filihia made the critical representations the Crown desperately wanted to use against Sio. The absolute bombshell was his direct statement. It was Danny who put me up to robbing the brothel. He gave me the knife and drove me there.
Wow, that's about as direct an accusation as you can get.
Ah.
Blaming Sio for the idea and the weapon.
It is. He also made other statements about the knife, saying it had come from him, meaning Sio, and later specifically naming Dan Sio as the one who gave it to him just before he went inside.
But weren't there inconsistencies or issues with his statements even then?
Oh, yes. The sources highlight several things. Filihia initially tried to claim self-defense,
Which the CCTV disproved.
completely contradicted by the footage showing him pursuing Mr. Gaudry. And crucially, at some point during the interviews, he asked the police officers something like, "Will cooperating help me?"
Ah, okay. That raises a flag about motive, doesn't it? Is he telling the truth or saying what he thinks police want to hear to get a better deal?
Exactly. So you have this mix. Direct implication of Sio, but also evolving accounts, claims contradicted by objective evidence, and a clear interest in his own outcome. All these factors became ammunition for the defense later when arguing about the reliability of these statements.
So, with Filihia unavailable to testify, these police interviews were the Crown's main weapon to pin the planning and the knife directly on Sio. Let's move to Sio's trial then, Supreme Court of New South Wales.
Yes, that's right. The judgment reference is 2013 NSWSC 1412. Sio faced 2 charges, murder and armed robbery with wounding. He pleaded not guilty to both.
But the facts of the actual robbery weren't disputed by the defense.
Not the core facts of what Filihia did, no. As we mentioned, formal admissions were made on Sio's behalf. They admitted Filihia did the armed robbery, had the knife, stabbed Gaudry, Gaudry died. The fight wasn't about whether the crime happened.
It was about Sio's involvement, his knowledge, his intent.
Precisely. The defense strategy was to stick to that initial story Sio told police. He just drove Filihia there for sex. No knowledge of a robbery, no knowledge of a knife. Trying to paint him as an unwitting chauffeur, essentially.
So the whole trial really hinges on whether the jury believes Sio was involved in planning and executing the robbery. And getting Filihia's statements admitted becomes absolutely critical for the Crown.
Absolutely make or break. And this is where they run smack bang into the hearsay rule, Section 59 of the Evidence Act, 1995 in New South Wales.
Okay, let's quickly break down hearsay again in this context. Why can't the Crown just play the tape of Filihia saying, "Danny gave me the knife"?
Because hearsay is essentially an out-of-court statement being offered in court to prove that what the statement says is actually true. Filihia said, "Danny gave me the knife," outside of the courtroom in a police interview. The Crown wants the jury to believe that statement is true, that Danny did give him the knife.
So using an out-of-court statement to prove the truth of its contents, generally not allowed.
Generally not allowed unless a specific exception applies. The rule exists because hearsay evidence isn't given under oath, and crucially, the person who made the statement isn't there in court to be cross-examined about it. The jury can't assess their credibility directly.
And the Crown obviously argued an exception did apply here.
They did. They relied on a few, but the one that became the central battleground all the way to the High Court was Section 65, subsection 2, paragraph DS 652D of the Evidence Act.
Okay, Essex 652D. What does that exception allow?
It allows hearsay evidence from someone who is unavailable to testify, like Filihia was, if two conditions are met. First, the statement must have been against the interests of the person making it at the time.
Okay, Filihia admitting involvement in a robbery, that seems against his interest.
You'd think so, yes. Although the defense would later argue about which parts were truly against interest versus self-serving. But the second condition is the really tricky one. The statement must have been made in circumstances that make it likely that the representation is reliable.
Ah, likely reliable. That sounds subjective.
It is. And that became the absolute crux of the legal fight. The Crown argued Filihia's statement implicating Sio, while bad for Sio, was also against Filihia's own interest, admitting robbery. And they argued the circumstances police interview under caution soon after the event made it likely reliable.
But the defense pushed back hard on that reliability point.
Oh, absolutely. They argued Filihia's statements were anything but reliable. They pointed to his potential drug influence, his shifting story about the knife, his contradicted self-defense claim, his asking if cooperation would help him. They said these circumstances screamed unreliability, especially the part implicating Sio, which could have been motivated by blame shifting. They argued it should be excluded under 652D and probably also under Section 137, the general discretion judges have to exclude evidence if its prejudicial effect outweighs its probative value.
So a real clash over interpretation.
Yeah.
How did the trial judge rule?
The trial judge ultimately admitted the evidence. The judge actually watched the video recordings of the police interviews, the ERSPs, and formed the view that Filihia appeared forthcoming, seemed genuine, not like he was reading from a script or had rehearsed it. Based on that observation and the formal setting, the judge concluded the circumstances did make the statements likely reliable enough to meet this S652D test.
Okay, so Filihia's damning statements, including the claim Sio gave him the knife, went before the jury. What did the jury decide?
The jury came back with their verdict on September 23, 2013. They found Sio not guilty of murder.
Acquitted of murder.
Acquitted of murder, but convicted him of the second charge, armed robbery with wounding.
Interesting. So they didn't think he had the intent for murder, perhaps under the joint criminal enterprise rules, but they did think he was part of the armed robbery and that it involved wounding.
That seems to be the implication, and the trial judge's comments at sentencing kind of reinforce this. The judge called the jury's murder acquittal potentially merciful.
Suggesting the judge thought maybe he could have been convicted of murder.
Possibly. But the judge then went on to state clearly that, based on the evidence accepted by the jury for the armed robbery conviction, Sio was the mastermind of the armed robbery. The judge listed Sio's role: planning it, getting information on the money, procuring the weapon, a knife, giving instructions to Filihia, and driving the getaway car.
So despite the murder acquittal, the court clearly saw Sio as deeply involved in the robbery itself. The conviction for armed robbery with wounding stood, and obviously Sio wasn't happy with that.
No. So the next step was an appeal. He took his case to the Supreme Court of New South Wales Court of Criminal Appeal, the CCA. The judgment is cited as 2015 NSW CCA 42.
And when did this happen? Who was involved?
The appeal was heard relatively quickly, on March 5th, 2015. The decision came down just a few weeks later, March 31st. The judges hearing the appeal were Justice Leeming, Justice Johnson, and Justice Schmidt.
And the legal teams? Same at the trial?
For Sio, the applicant, it was Mr. M.W. Smith leading the argument this time. For the respondent, the Crown, it was Mr. G. O'Rourke.
Okay, what were the main arguments Sio's team made at the CCA? Was it just the hearsay issue again?
That was a major part, yes. But they pursued two main grounds. First, they argued the jury's verdict, guilty of armed robbery with wounding, was unreasonable, basically saying no reasonable jury could have convicted him on the evidence presented.
A high bar to meet, usually.
It is. The second ground was, indeed, challenging the trial judge's decision again. Specifically, the admission of Filihia's police interviews under those hearsay exceptions, focusing heavily on the reliability requirement of 652D.
So they were essentially rerunning the arguments from the trial. Filihia was an unreliable accomplice, motivated to shift blame, His story changed, the circumstances didn't guarantee reliability, so his statements implicating Sio should never have gone to the jury.
Exactly. That was the core of the admissibility challenge. They hammered on the inconsistencies, the self-defense claim, the will cooperation help me question, all pointing away from reliability, they argued. The Crown naturally defended the trial judge's decision, repeating that the formal circumstances of the police interview did support reliability. Filihia seemed coherent, it was close in time to the event, etc.
How did the CCA judges rule on these two grounds? Did they agree with Sio?
They granted him leave to appeal, which means they thought the points were arguable, but ultimately they dismissed the appeal against his conviction.
So they upheld the conviction. On what basis?
Their reasoning on the unreasonable verdict ground is interesting. They focused almost entirely on the non-hearsay evidence. They said even if you put Filihhia's statements about Sio giving him the knife completely aside, there was still enough other evidence for a jury to convict Sio of armed robbery.
What evidence were they pointing to?
Mrs. Gaudiossi's evidence about the early planning, the diagram, the note about Brian's money. Mr. O'Hare's evidence about overhearing the robbery plans, the knife going missing, Sio and Coffison lying about it, Mrs. Coffison being in the car, the formal admissions about Filihhia's actions. The CCTV. The CCA said all that circumstantial evidence taken together made it undoubtedly open for the jury to be satisfied beyond reasonable doubt that Sio was involved in the armed robbery.
Okay, so they found the core armed robbery conviction was supportable even without the contested hearsay.
That was their finding on the first ground, yes. It's worth noting, though, they didn't really dig into the with wounding part, specifically in that analysis, the issue of Sio's foresight, which is needed for that aggravated offense. They focus more on the base armed robbery.
And what about the second ground, the admissibility of Filihhia's statements under S652D? Did they find the trial judge got that right?
Yes, they did. The CCA essentially agreed with the trial judge's assessment. They found the conditions for admitting the evidence under S65 were met. They acknowledged the trial judge's impression of Filihia appearing forthcoming and not rehearsed, although they did note, as the defense pointed out, that Filihia, seeing the CCTV and learning Mr. Gaudry had died before making some of the key statements, could have affected him. But they didn't think it rendered the statements inadmissible under the circumstances test.
So Sio loses again. The CCA upholds the conviction for armed robbery with wounding. His options in the state system are exhausted now.
Pretty much. The only place left to go was the High Court of Australia.
The highest court in the land. But getting there isn't automatic, is it? You need special leave.
Exactly. Special leave to appeal is required for most cases, especially criminal ones. You can't just appeal as of right. You have to persuade the High Court that your case involves a really important question of law, something of public significance, or that a substantial miscarriage of justice has occurred that needs correcting. It's a gatekeeping mechanism.
And Sio applied for special leave.
He did, and crucially, it was granted. That signals the High Court saw significant legal issues in play here that warranted their attention.
Who are the High Court judges who heard this final appeal?
The bench that heard the special leave application, which was actually referred to the full court for argument, alongside the appeal itself and the substantive appeal, included Chief Justice French, Justice Bell, Justice Gagler, Justice Keene, and Justice Gordon, a full bench of 5 justices.
And the legal teams arguing before the High Court. We should note them for the record.
Yes. The case is Sio v. the Queen, 2016 HCA 32. For the appellant, Daniel Sio, his case was argued by Mr. T.A. Game S.C., appearing with Mr. J.L. Roy. They were instructed by Sydney criminal and traffic lawyers.
Okay, Game S.C. for Sio and the Crown.
For the respondent, the Queen, the argument was led by Mr. L.A. Babb S.C., appearing with Mr. G.M. O'Rourke S.C., who had appeared at the CCA level. They were instructed by the solicitor for public prosecutions for New South Wales. The sources also mentioned Mr. Arcalera and Mr. Pickering having been involved in earlier preliminary mentions representing Sio at different points.
Right. So what were the specific points Mr. Game S.C. raised for Sio in the High Court? What did they focus on?
They focused on 2 main issues. First, the consequences flowing from what they argued was the trial judge's failure to properly direct the jury on a critical element of armed robbery with wounding. Specifically, the element about Sio needing to have foreseen the possibility of wounding with the knife as part of their joint plan.
Okay, a misdirection argument and the second issue.
The second issue went right back to that core evidence dispute. Whether the trial judge, and by extension the CCA, had made a mistake, an error of law, in deciding that Filihhia's statements, particularly the claim Sio gave him the knife, were admissible under Section 65(2)(d).
And it was this second point, the hearsay admissibility, that got them special leave.
Yes, the High Court explicitly granted special leave on that second ground, stating it had a material bearing on the disposition of the case. They clearly wanted to rule on the proper interpretation and application of S65-2 reliability requirement, especially concerning accomplice evidence.
So the stage was set for a major high court examination of accomplice hearsay. But then something pretty dramatic happened regarding that first ground, the misdirection issue.
It really did. A critical turning point in the High Court hearing itself. The Crown. Well, they conceded.
Conceded what?
The Crown conceded that the trial judge had failed to direct the jury properly on that foresight element for armed robbery with wounding. They accepted that the directions given didn't adequately explain that Sio needed to foresee the possibility of Filihia inflicting a wound with the knife during the robbery.
Wow, that's huge. The prosecution basically admitting the trial was flawed on that point.
Yes. And the Crown further accepted that because of this misdirection, Sio's appeal had to be allowed, and his conviction for armed robbery with wounding had to be quashed.
So just like that, the conviction is gone. That resolves the first ground of appeal. But it leaves the big questions hanging, doesn't it?
Absolutely. The concession confirmed the conviction couldn't stand, but it immediately shifted the focus to two things. First, what did the High Court think about the Kingsanic 5-2 issue, the reason they granted leave? And second, what should happen next? Should Sio be acquitted altogether, or should there be a new trial for a lesser charge, like simple armed robbery?
And the answer to that what next question depended heavily on how the High Court ruled on the admissibility of Filihia's hearsay, right?
Precisely. The two issues were now completely intertwined.
Okay, let's really drill down into that S652D argument in the High Court. This was the legal heart of the matter, the reason special leave was granted. Remind us again. S652 requires the statement to be made in circumstances that make it likely that the representation is reliable. How did Mr. Game SC for Sio attack the lower court's findings on this?
Mr. Game argued that likely to be reliable isn't just a low bar. He submitted it means the circumstances have to make it more probable than not that the statement is actually true or accurate. And crucially, he argued you can't just look at the general setting like, oh, it was a police interview, under caution, so it's probably reliable.
You have to look deeper.
Much deeper. He argued the assessment must consider the circumstances specific to that particular representation being made. This includes everything relevant to the speaker's credibility at that specific moment. Who are they? What are their potential motives? What else have they said?
So context is everything, especially the speaker's own position.
Exactly. And Mr. Game went through Filihia's interviews, pointing out all the things suggesting unreliability. The initial false self-defense claim, totally blown up by the CCTV, the way his story about the knife seemed to evolve.
Can you recap that evolution?
Sure. According to Mr. Game's submissions, based on the transcripts, Filihia initially says something like, Jacob, Sio's alias, already had the knife. Then later it had come from him, Sio. Then, in response to a leading question from police like, he gave it to you, he agrees. It's only much later, after seeing the confronting CCTV footage and learning Mr. Gaudry had died, that he specifically names Dan, Sio, as the one who gave him the knife just before he went in.
That progression does sound less than straightforward.
Mr. Game argued this changing story, these inconsistencies, these documented falsehoods like the self-defense claim, actively pointed away from reliability. And then there was Filihia asking police if cooperation would help him. That suggests a clear potential motive, right? Maybe he's thinking, if I give them the mastermind, maybe I get treated better.
So the argument is an accomplice implicating someone else is inherently suspect.
That was a core point. Mr. Game submitted that a question mark automatically hangs over the reliability of an accomplice's statement pointing the finger at a co-accused. It arises necessarily from their status as an accomplice. And he argued that nothing else in the objective circumstances of Filihia's police interviews positively affirmed the likely reliability of the specific claim about Sio providing the knife. Nothing strong enough to overcome that inherent doubt. He also criticized the lower courts for seemingly treating all the interviews and statements as one big block. He argued this prevented a proper analysis of how the circumstances changed during the interview process, seeing the CCTV, learning of the death, and how those changes might have influenced Filihia's motives or truthfulness at different points. It kind of papered over the cracks, he suggested.
And he used that comparison with Section 83 of the Evidence Act again.
Yes, very effectively. He reminded the High Court that under S83, if Sio and Filihia had been tried together, Filihia's police interview admission implicating Sio would have been completely inadmissible against Sio. It's a fundamental rule protecting co-accused.
So using SS52D after separate pleas felt like a way around that protection.
Mr. Game argued it would be a stark contrast and potentially unfair if the Crown could achieve the same result, getting Filihia's accusation against Sio into evidence simply by virtue of them being tried separately, using this hearsay exception, unless the reliability requirements of S652D were interpreted and applied very strictly. The caution underpinning S83, he argued, should demand extreme care when considering accomplice hearsay under S652D. As he put it to the court, essentially, none of this interview would touch his client in a joint trial.
A powerful argument framing the potential unfairness. How did Mr. Babb SC for the Crown respond to this sustained attack on the reliability finding?
Mr. Babb stuck to the interpretation that the primary focus of S652 is on the circumstances surrounding the statement, not a direct judicial assessment of the statement's ultimate truth. He argued the objective circumstances were favorable. Police station, under caution, Filihia seemed sober. Interview was soon after the event. These formal circumstances, he argued, were enough to make the representation likely reliable, as the Act requires. He also stressed that much of Filihia's account was accurate and corroborated by other evidence. Sio driving, the location, the stabbing, the money being taken. He argued the inconsistencies about how Sio provided the knife or the exact sequence were relatively minor details in the grand scheme of an otherwise broadly reliable account given in reliable circumstances.
So the Crown's view was, focus on the setting and the overall consistency, don't get bogged down in minor discrepancies or potential motives.
Essentially, yes. He argued the multiple interviews were conducted in largely consistent circumstances, and the changes weren't significant enough to destroy the reliability stemming from that formal caution setting. He also downplayed the blame-shifting motive, pointing out Filihia consistently admitted his own role in the stabbing and claimed it was only meant to be a robbery, not involving injury, suggesting he wasn't trying to completely minimize his own culpability.
It really comes down to that fundamental question. What exactly does circumstances that make it likely that the representation is reliable mean in practice, especially with accomplice evidence? Setting versus substance.
That's the precise legal knot the High Court had to unravel. Okay, so the armed robbery with wounding conviction is definitely quashed because of the Crown's concession on the misdirection. Now the High Court has heard the arguments about the S652D hearsay issue. What happens next? What order should they make?
Right, the big debate. Acquittal or retrial? What did each side argue for?
Mr. Game, for Sio, argued forcefully for an outright acquittal on the armed robbery with wounding charge. He didn't want a retrial. Furthermore, he argued that even ordering a retrial for the lesser offense of simple armed robbery would be wrong.
Why wrong? Armed robbery was clearly part of the original charge.
He argued it would be inimical, basically, harmful or contrary to established legal principles, particularly around issue estoppel and preventing relitigation, what's sometimes called incontrovertibility. He felt allowing the Crown to run a new trial specifically for armed robbery, which wasn't a separate count on the original indictment, just a potential alternative verdict, would be giving them yet another bite at the cherry.
Like a second chance to make their case after messing up the first time.
Exactly. He argued it was unfair to let the Crown try and make good a case that it had failed to do with the first trial, especially now that the critical hearsay evidence from Filihia about the knife was under such a strong challenge and likely to be ruled inadmissible. He framed it as procedural unfairness.
So Sio's position, quash the conviction, enter an acquittal, end of story.
That was their primary goal.
And the Crown's position, Mr. Babb.
Mr. Babb argued that if the conviction was quashed, the standard and appropriate order should be a retrial generally. This would allow the Crown prosecutor the discretion to present a new indictment, most likely for the lesser offense of armed robbery. He argued this was clearly in the public interest, given the seriousness of the underlying crime.
He argued a retrial for armed robbery was fair.
Yes. He contended it wasn't a radical departure from the original case, and importantly, that a viable case for armed robbery still existed, even without relying on Filihia's hearsay about Sio giving him the knife. He pointed back to all that non-hearsay evidence the CCA had relied on: Gaudry, O'Hare, Coffison, the admissions, the CCTV. He argued that evidence alone was enough to potentially secure an armed robbery conviction at a fair retrial.
So the Crown believed they still had a case, even without the contested hearsay.
They did. They argued armed robbery was always available as a common law alternative to the armed robbery with wounding charge, and a retrial on that basis was perfectly appropriate.
So the High Court is weighing the legal error on hearsay against the conceded misdirection, and balancing principles of finality against the public interest in prosecuting serious crime. A complex decision.
Absolutely. They had to rule on the hearsay admissibility definitively and then decide the fairest consequence flowing from both the misdirection and any error found in admitting the evidence.
Okay, the moment of truth. What did the High Court ultimately decide? What were the final orders?
The High Court delivered its judgment and orders on August 24, 2016. The orders were special leave granted, appeal allowed. The order of the Court of Criminal Appeal was set aside. Sio's conviction on count 2, armed robbery with wounding, was quashed.
Yeah.
And crucially, a new trial be had for the offense of armed robbery.
A new trial. So Sio won the appeal, got the conviction quashed, but didn't get the acquittal he wanted. He had to face trial again for simple armed robbery.
That's the outcome. They agreed with the Crown's concession. The conviction had to be quashed because of the trial judge's misdirection on the foresight element for the wounding. That was clear.
But what about the hearsay? Did they agree with Sio that it was wrongly admitted?
Yes, they did. And this is the really significant part of the judgment, the lasting legal legacy. The High Court explicitly found that the trial judge, and therefore the Court of Criminal Appeal in upholding that decision, had erred in admitting Filihia's statements under S-652.
So Mr. Game's arguments about reliability won the day.
They did. The High Court provided that vital clarification on how to interpret the likely reliable circumstances requirement in 652.
What was their interpretation? How did they say courts should assess it?
They confirmed that, yes, the focus is on the circumstances when the statement was made. But, and this is the key bit, those circumstances are not just the physical setting. They include the context provided by other statements the person made, and critically, factors relevant to the speaker's own credibility and potential motives operating within those circumstances. You can't just tick boxes. Police station, caution, sober. You have to look at the whole picture of the speaker and what they're saying. The court specifically addressed the accomplice issue. They stated that the question mark over the reliability of Filihia's claim that Sio gave him the knife arose necessarily because Filihia was Sio's accomplice. That status itself creates inherent doubt.
So the starting point is caution when dealing with accomplice hearsay.
Yes, and that inherent doubt needs to be overcome by other circumstances that positively point towards the likely reliability of that specific claim. The High Court looked at Filihia's situation and found nothing in the objective circumstances that positively affirmed the reliability of his assertion about Sio giving him the knife. In fact, they found the opposite.
How so?
His changing story about the knife, his false self-defense claim, his question about cooperation, the High Court said these factors detracted from, rather than supported, the likelihood that his claim against Sio was reliable. Even if the trial judge thought he seemed forthcoming, the High Court looked harder at the substance, the inconsistencies, the motives, and found the S-65 reliability test was simply not met for that crucial assertion.
So a much more rigorous, context-sensitive approach to reliability is required, especially for accomplices. Yeah, it's not just about the formalities of the interview.
Exactly. You have to scrutinize the content, the consistency, the speaker's potential biases and motives within the interview setting. Being under caution doesn't automatically make an accomplice's blame-shifting statement reliable.
Okay, so the High Court rules the key hearsay evidence was wrongly admitted. How did that influence their decision to order a retrial instead of an acquittal?
Because that evidence, Filihia's statement about the knife, was so central to the Crown's case, directly linking Sio to the weapon, and therefore strengthening the case for his participation in the armed robbery, not just being present, its wrongful admission meant the original trial was fundamentally flawed. It constituted a miscarriage of justice.
Meaning the High Court couldn't just substitute a conviction for the lesser offense.
Precisely. They couldn't simply say, well, the jury convicted him of armed robbery with wounding, so they must have been satisfied of armed robbery, let's just substitute that verdict. They couldn't do that because the jury reached that original verdict having heard powerful, persuasive evidence, Filihia's hearsay, that they shouldn't have heard. The wrongful admission tainted the process.
So the only fair remedy was a completely fresh start.
Yes. A fresh determination by a new jury, hearing only the admissible evidence, was required. That's why they ordered a new trial specifically for armed robbery, allowing the Crown to present its case based on the non-hearsay evidence, Gaudry, O'Hare, Coffison, etc., and whatever other admissible evidence they had, but without using Filihia's police statement about Sio giving him the knife to prove that specific fact.
So the outcome: conviction quashed due to misdirection, key hearsay ruled inadmissible, new trial ordered for armed robbery. A complex result with huge implications.
Absolutely. Sio avoided the more serious conviction but faced prosecution again, and the Crown had to proceed without one of its strongest pieces of evidence against him.
This case, Sio v. the Queen, clearly resonated far beyond Daniel Sio himself. How exactly has it changed legal practice in Australia? What's its main legacy?
Its primary legacy lies in how it significantly clarified and arguably tightened the rules around admitting hearsay evidence under the Uniform Evidence Acts, especially when that evidence comes from an unavailable accomplice.
Particularly that crucial reliability test in Section 65.
Yes, absolutely. The High Court's decision provided much-needed guidance on interpreting circumstances that make it likely that the representation is reliable. It decisively moved the focus beyond just the superficial formal aspects of how a statement was taken.
So judges now have to dig deeper into the context.
They do. They need to conduct a more searching analysis. Look at the statement itself, how it fits with everything else the person said. Consider their potential motivations, especially the powerful motive an accomplice might have to lie or shift blame, and ask, do the circumstances, viewed realistically, positively indicate that this specific assertion is likely trustworthy?
It sounds like it reinforces the caution courts should always have with accomplice evidence.
Very much so. The ruling underscored that an accomplice's statement implicating someone else, even if it partly admits their own guilt, is inherently problematic. That inherent doubt isn't wiped away just because it was said to police under caution. The prosecution needs to point to specific circumstances that affirmatively demonstrate likely reliability to overcome that doubt and satisfy S652.
So, has it made it practically harder for prosecutors to get accomplice hearsay admitted?
I think that's a fair assessment, yes. It raised the bar. It requires a more rigorous justification than perhaps was sometimes accepted previously. Prosecutors can't just rely on the formalities of the interview. They need to address potential credibility issues head-on and show why, despite those issues, the specific statement is likely reliable in its context. The case also highlighted the important interplay between 65(2)(d and other evidence rules like Section 83 prohibiting the use of one co-accused admission against another in a joint trial, or Section 165 requiring warnings about unreliable evidence, or Section 137 allowing exclusion for unfair prejudice. The High Court's approach to S65(2)(d aligns better with the protective policies behind those other rules. It makes it harder to use the hearsay exception as an easy end run around the concerns about unreliable or prejudicial accomplice testimony.
So, Sio v. the Queen wasn't just about one man's appeal. It set a clear precedent, guiding courts across Australia on how to approach this critical type of evidence.
Exactly. It clarified a complex and contested area of evidence law, impacting how criminal trials involving multiple offenders are conducted, especially when key players aren't available to testify. It really emphasizes the court's duty to be a gatekeeper, ensuring that evidence juries rely on is not just relevant, but sufficiently reliable to ensure a fair trial.
It's quite a journey, isn't it? From that desperate, violent plan unfolding in the dead of night.
Yeah, fueled by drugs and ending in tragedy.
Through multiple court battles, arguing over intricate legal rules.
All culminating in the nation's highest court, meticulously dissecting the meaning of likely reliable circumstances.
It really does show how these seemingly abstract legal principles have such a concrete impact, both on the people involved and on the way justice is administered.
It absolutely does. It's a stark reminder that the rules of evidence, like Section 652(d), aren't just technicalities. They're fundamental safeguards. They're there to try and ensure fairness, to make sure convictions are based on solid ground, especially when dealing with powerful evidence like an accomplice's accusation that can't be tested by cross-examination.
And it leaves us with that really challenging question, doesn't it? The one this case throws into sharp relief.
Yeah, how do courts strike that balance? The balance between pursuing justice for victims, holding offenders accountable for society,
and in protecting the fundamental rights of the accused, particularly the right to challenge the evidence against them. How much weight can we, or should we, give to statements from people caught up in the crime themselves, people who might have every reason to point the finger elsewhere?
even if they admit their own part to some extent? The Sio case really forces us to confront those inherent difficulties in finding truth and ensuring reliability within our adversarial system. It's a constant tension.
Powerful questions to reflect on, long after the case itself is decided. Thank you for walking us through such a complex and significant case today.
My pleasure. It certainly shows how one tragic night can lead to profound legal consequences.